morning, students. Today we're going to understand and we're going to start our new topic, which is Introduction of Criminal Law in India. We have already discussed this chapter before also. So today I'll just give a brief of this chapter, the whole chapter, till the portion we have already done with. And now let's start with the brief introduction of this concept. Introduction of criminal law in India. So, crime. First of all, we have to understand the term crime, because criminal law deals with crime only. Then what does crime means? Crime means an unlawful act, and this unlawful act is actually punishable by law, or you can say it is punishable by the state. In other words, you can also say that a criminal law is unless an activity is prohibited by law, unless an activity is prohibited by law, it does not qualify as crime. So, in other words, I am saying that an act or any activity which is actually prohibited by the law or the state is crime. And to curb those activities, to deal with those activities, to actually impose punishment on those crimes, there is a need of certain law, and that law is basically called as criminal law in our Indian system. Now, there are many examples for criminal laws, because there are certain sets of criminal laws in our country, which deals with different types of criminal activities. Some laws used to impose punishment, while the other laws, like procedural laws, used to prescribe the procedures that in which way the investigation will going to happen, the inquiry will going to happen, and later on the trial will take place. So, for example, in our Indian legal system, IPC is the substantive law. इंडियन पिनल कोड, इसे हम हिंदी में भारतीय दंड संहिता भी कहते हैं, जो कि डील करती है, which deals with imposing punishment on crimes, not only impose punishment to the crimes, but in IPC all the categories of crimes are explained also, like robbery, dacoity, theft, whatever it is, whatsoever crime it is being explained in IPC. IPC was actually came into force in 1862. Sorry, my mistake, it's 1892. And it was drafted by Lord Macaulay. Later on, this penal code is actually applied in whole of the India except Jammu and Kashmir. In Jammu and Kashmir, there is Ranbir penal code, and there is one more catchy fact, that in Pakistan there is a similar penal code, because at the time of the enforcement, at the time of the effectiveness of this IPC, India and Pakistan were not divided. So the Pakistan Penal Code is also very much similar to the Indian Penal Code. Now moving to our next topic, the categories of crime. As I've already said that there are certain categories of crime and they are also explained in IPC. There are there are categories of crime now. To in modern times there are different set of crimes which in the modern world uh, many new crimes have been evolved. Like previously we were only having few crimes, very known crimes like crime against persons, crime against property, crime against persons includes murder, aggravated assault, rape and robbery. Crime against property includes crime again include crime against property includes the crime against somebody's property like burglary, larceny, theft, and etc. Crime against morality is another set of crime like defamation and other sort of crimes. Nowadays, there are different set of crimes which have been in the modern era. They are introduced in a short span of time. These crimes are white collar crimes, organized crimes, and so on. Now these white collar crimes and organized crimes are actually dealt with some other act which impose punishment on these types of crime. For the white collar crimes, many of the acts have now been introduced like economic offender bill for the fugitives uh, who used to just embezzle the Indian money and then they used to leave the country and escape from our country. So for those people, for those fugitives, there is one bill which has been introduced. Now let us talk about the stages of crime. When we talk about stages of crime, then there are four types of stages. There are four types of stages. We have already discussed all these things. I'm again just briefing out these things so that you can just be able to understand it more easily while going through the assignment which was given to you previously. The first one is intention. Intention. The second one is preparation. Preparation. The third one is attempt. The fourth one is corruption. Corruption. Wrongly written. Sorry. That is not corruption. It is completion. Sorry. Completion. Completion or accomplishment. So there are different stages of crime. First one is intention, second one is preparation, third one is attempt, and the last one is accomplishment or completion. In the first two stages, remember, in the first two stages, the person while intending or making preparation, he'll not be held liable. He'll not be held liable and he will not be punished in the first two stages. Generally it happens that in these two stages the person is not punished and he is not made liable for any crime in these two stages. But there are certain exceptions for these for the first two cases. which I have dealt before also. So just go through the notes and take a glance of that. Now, this third stage is attempt. Attempt is something where a person has attempted the act of crime and it has just missed the accomplishment. It has just missed the completion. So at this stage, the person is held liable for attempt. Like in the case of murder, if the person, if there is a person X, Y, there are two persons and X shots Y, while Y bends down and the bullet just goes through him and he is not being injured. So at this stage, at this incident, the attempt to murder means the X will be liable for attempt to murder, because if the gunshot has been hit to the person Y, then he should have been killed at that particular time. And if he has been killed, then the fourth ingredient, the fourth stage was fulfilled and he will be liable for murder. Hope you have understood. Now, the next topic is element of crime. There are basically, in your book, there are three elements which are discussed, but we are going to understand the four major elements. First and foremost element is human being. Human being. If I say human being, then only human beings are made liable for the act of crime, not the animals. Secondly, actus reus. Actus reus. Guilty act. We have already discussed this. Guilty act. And third one is mens rea, guilty mind, which is guilty mind. We have done all these things with the case law, with the relevant case laws. Just go through the notes and the assignments. You're going to find out the notes, the relevant case laws on these particular topics. And the last one is injury. So these are the main four elements of crime. Elements of crime contains four elements. First is human being. Second one is actus reus, means there has to be a guilty act in a crime. Third one is mens rea, means there has to be a guilty mind. And the last one is injury has to be caused on the person on whom the crime has been committed. Now, there is a distinction between intention and motive. We have discussed this also in our previous class. So, in this we have learned, we have already discussed that intention means something that is done willfully and not accidentally or mistakenly. So, intention is enough to make somebody liable for his crime. Means intention is enough to make a person or to affix criminal liability on a person. But in the case of motive, It is an ulterior object behind doing an act. Behind doing an act. It is the driving force behind intention or commission of an act. So, the motive is not essential for affixing criminal liability. But if there is an intention of causing crime, then the person can be held liable for that, and we have discussed this topic previously. Just go through the notes. Now, objectives of criminal law. When we talk about objective of criminal law, actually we are actually referring to, the theories. There are different theories which are related to criminal laws, and those theories are, the first one is the retributive theory. I'm really sorry, the marker is not working, so let me try this. Retributive theory. Retributive theory. Second one is deterrence theory. Third one is incapacitation. Citation theory. Rehabilitation. And the last one is restitution. So these are the theories on which the criminal law is based on. Means these are the objectives of a criminal law. So we're going to discuss about the first theory, which is retributive theory, and it says that an eye for an eye and a tooth for a tooth. Means the punishment, or you can say that this theory is basically deals with righting of balance. If a criminal has done a wrong towards a person or property, he needs to be given a penalty in a manner which balances out the wrong done. For example, if a person has committed murder, he can be delivered capital punishment to balance the suffering caused to the victim. Now, in the next theory, deterrence theory, here actually we used to deter the person who has done the crime. Deter means हिंदी में इसे कहते हैं डराना. So deterrence serves as a major tool in maintaining the general law and order in the society, especially from the perspective of crime. Criminal acts are penalized so as to deter individual from not repeating it again. Means to deter a person who is committing a crime so that the person does not repeat the crime again and again. Now the third one is incapacitation. Now in this theory, we actually segregate that person to some different place. We just remove that person from the society. The objective of this theory is to segregate the criminals from the rest of the society. For the crimes committed, they suffer a kind of banishment by staying in a prison, and in some cases they are also subject to capital punishment. Now later on, as the time has been evolved, this theory has taken a large phase and it's been introduced as rehabilitation theory. In this theory, actually, we used to reform the criminal offenders. Aim of this theory is to transform the offender into a valuable member of a society. And the last theory is restoration theory or restitution theory. In this theory, the goal is to repair through state authority any injury inflicted upon the victim by the offender. For example, one who embezzles will be required to repay the amount improperly acquired. Now, sources of criminal law. In sources of criminal law, we actually used to study about the several legislation dealing with criminal law. However, two important sources are there. First is, I've already told you all that one is IPC, it is a substantive law. The second one is Criminal Procedure Code. It is also being called as CRPC. In IPC, if punishment and other things are explained, means imposing punishment and the definition of the different types of crimes are given in IPC, then in CRPC, all the procedures of investigation, what will be the powers of the court, what will be the way of inquiry, and later on the trial process comes. So it is the procedural law. In the same way, there is one more law which we call as Evidence Act, through which we used to collect the evidence by which we used to prove certain criminal act or activity. So it is also one of the very important legislation, or you can say source of criminal law. And there are, as I've already told, that in the modern times there are certain new crimes which have been evolved. The legislation have made many special legislation related to different set of crimes, like crimes against SC/ST, like Adultery Act, Dowry Prohibition Act, Prevention of Corruption Act, and so on. So for today, it's, I think the brief has been already dealt with you before also and today also. So now just go through the assignment and notes given to you. Hope everybody has understood the topic introduction of criminal law, and we're going to discuss the further in the next class. Thank you.